So the advice I always give to our clients is when you're describing the issue to the service writer, that person who's actually writing down your complaint when you drop off your vehicle, try to use the same lingo each time. Try to use the same verbiage each time so that it's being written down the same way.
I'm Emma.
And I'm Courtney.
And this is Lemon Law Unpeeled, the Lemon Law podcast. Today, we're going to walk you through a typical lemon law claim, including the roles and responsibilities of your attorney, how an attorney can help assist in your claim, both before the claim starts, during, and after, to help you understand why having an attorney is so important when dealing with these types of issues. So, Courtney, I'll let you kick it off with just discussing, start from the beginning, the initial evaluation. What do we look for in a lemon law claim? When do we feel a lemon law claim is ready to move forward? What are the main key points that you're looking for when you're evaluating a case?
Yeah, I think the first thing we always ask is what's the year of the vehicle and how many miles are on it? Because as we've discussed previously, that's really the qualifications in any state. It goes according to age and mileage of the vehicle. How old is it? How many miles do you have on it? How many times has it been back? So those are really the bullet points. Age, mileage, how many times have you been back? And then as we get a little bit more into it, if you meet those guidelines, the vehicle's new enough, has few enough miles, you've been back enough times, or the vehicle has been out of service enough number of days, we then want to know what's the issue, because that's going to help determine what type of remedy you can get. Is it a more serious issue that would warrant a buyback? Is it a less serious issue that would warrant a possible cash and keep offer? But those are things that we get to once we know you basically qualify in the general framework of age, mileage, how many times has the vehicle been back?
Right. And usually the next step after that is to get the vehicle's repair orders, right? We take a look at that documentation to see, okay, what really is going on here in the sense of what evidence do we have to present to be able to show that we have a lemon law claim. So what do you mainly, when you're looking at repair orders, Courtney, what are you looking for? What are the main items that are very important to you to have within them?
Yeah, when I'm looking at a repair invoice, I'm looking to see what's the date on them and what's the mileage on them so that I can tell that the vehicle was there within the requisite amount of time. And then what was the complaint? Is the complaint documented on there? Unfortunately, potential client coming to us and saying, I was complaining about this or that, just their word isn't going to be enough for us to really be able to help them. We need to see that complaint on a repair invoice. And generally the language will say something to the effect of C/S, which stands for client states, and then you'll see their complaint on there. It's best when that complaint is then verified. A lot of times it will say test drove, verified issue, and then it will talk about the repair that it made. It's not catastrophic to the claim if the vehicle wasn't, or if the issue wasn't verified. We certainly have had success with those. Generally, then the repair invoice will say something to the effect of CND, which stands for could not duplicate or could not verify complaint. Those are an uphill battle, though. We really like to see that the issue was complained of, the issue was verified, and a repair was made. That's what's going to give us the most clear-cut way to success.
Right. So it's really uncommon, actually, to have a case where every single visit the complaint is verified. So it's not abnormal to have, 2 out of 3 visits or 1 out of 3 visits where they can't duplicate the problem. But usually our requirement is we need to see that at least once the dealership confirmed that there was an issue and performed some sort of repair. Because if we have every single visit and they're just repeatedly saying cannot duplicate, those are the hardest cases that we have. And just frankly, we don't usually accept them. Because first, we have to show that there's even a problem with the car. And what that's going to come down to is just expert versus expert. It's going to be our guy versus their guy in court saying whether there's a problem or not, which is really not what you want to hang your hat on. It's not the strongest case that we could have to push it forward. So usually we recommend either trying a different dealership to see if they'll maybe take your complaints more seriously, or if they'll do a test drive with you to try to get that confirmation, because that is the main kicker for these cases. Did the dealership say, yes, there's an issue here? Because if they didn't, the manufacturer is just going to look at these repair orders. What did our technicians say? Our technicians are saying there's nothing wrong with this car, so we don't owe you anything.
Yeah, that's absolutely true. And like you said, it is very common to see the could not duplicate or the could not verify come up at certain points in the repair invoices. But as long as we have one good verification, we're generally good, especially if that verification or duplication came toward the end. If we have a few could not duplicates and then the issue is finally verified, it makes it look like, oh, look, I wasn't making it up. There really was an issue all along. When the issue is verified on the first occasion, and then we have a string of could not duplicates, that might be a little bit tougher. Certainly nothing we can't possibly overcome, but when we have that verification toward the end, that's always best.
Yeah, absolutely. That's funny. That was just about what I was going to say going into this is the timing of everything and the order in which the complaints are verified is really important too, because it is a sort of case by case basis that we have to look at these claims, right? Just because we have a case where they verified it once doesn't necessarily mean, oh, we've got a winner. It just really helps push the claim forward for us. But the actual timing of the visits, the timing of the issues, the type of issue that they have, the type of repairs that are being done, all really come into play. And what's important too is these repair orders, Courtney, as you know, these dealerships like to take a lot of creative liberties when they're writing them up in terms of what the actual complaint is. I've had cases where I've had to call a client and say, okay, I see a complaint here of a front end squealing noise, but then later I see a complaint of a vibration while driving. I don't see three of the same. And they're like, well, that was the same thing. It vibrates and it makes a squeal. But looking at it on its face, it seems like two different issues. So it's best to be really careful when you're picking up that vehicle to review that repair order and ensure that what you told the dealership is on there, along with what they told you being there too. I actually have a case going right now where the client, when I talked to them at the initial intake, said, oh, no, the service manager told me they can make it happen. They know how to duplicate this issue. They've seen it happen, because I was basically saying to him, listen, if they've never duplicated this problem, we're going to have an uphill battle. But he assured me that the service manager told him this was an issue that we've replicated. Lo and behold, I get the repair orders and that doesn't say it anywhere on there. And I tried to get the manufacturer to reach out to the service manager. I've tried to facilitate, some sort of phone call with all the parties involved, but they're not willing to do that. They just want to look at the repair orders, look at the tech notes, see what those say. And if it doesn't have anything on there in relation to a concern being duplicated, then in their minds, them meeting the manufacturer, there is no issue here.
Yeah, that's absolutely true. I had a client email just this morning saying, well, we verbally discussed this, and I think it was on a recorded line. So could we use that as evidence? And unfortunately, it's just not that easy. It's really the repair invoices that are the end all be all. So the advice I always give to our clients is when you're describing the issue to the service writer, that person who's actually writing down your complaint when you drop off your vehicle, try to use the same lingo each time. Try to use the same verbiage each time so that it's being written down the same way. Sometimes you're actually the one to write it down. If you make the appointment online, you actually type in what your complaint is. Try to describe it the same way each time, because that's what's going to be translated directly onto the repair invoice. And then the biggest thing is, Emma, like you said, read that invoice. When you pick up your vehicle, they hand you that invoice, they give you your keys, and they ask you to sign off on that invoice. Read it before you sign it. If it's not accurate, if it doesn't accurately describe what you complained about, if you complained about 3 things and there's only 1 or 2 things written on there, tell them that and ask them to amend it. They will. It is a whole lot harder to go back and have them amend it days later after you've submitted it to us and we've told you about this, and then you call the dealership and ask them to amend it. It's probably not going to happen. But if while you're still standing there before you sign off on it, you notice that it's not right, ask them to amend it. And Emma, also like you were saying, if they made a repair, make sure that's on there. If they verified the issue, make sure that's on there, because those repair invoices are our greatest and oftentimes our only source of evidence. It's all the manufacturers really want to rely upon.
Right. And when you go to pick up your vehicle, they'll sometimes tell you, well, the repair order's closed. I can't reopen it or change it. But what they can do is they can make an addendum, meaning they can open up a new ticket, write in, client came to pick up vehicle, X, Y, and Z was missing from the repair order, and they put it on there. So that works too for me. Like, as long as it's type written on the repair order from the dealership, that works. It's when they're, I'll handwrite it on here, that everything, was duplicated or all handwritten on here, that our tech did confirm it, but just one time. That's not good enough either, because who's to say who wrote that? We can't bring a handwriting expert in to say, oh, it was definitely this person. It doesn't work that way. Even if they sign it, even if they initial it, it just is too flimsy, unfortunately. It's not strong enough. So you want them to open up a new ticket, make that addendum, and print it out for you so that you have that in your hand. Because otherwise, it's just going to fall flat. And I do have clients, and Courtney, I'm sure you've had this too, where they say, well, if we go to court, call in the service manager, have them testify. They'll tell you that they duplicated it. I mean, I'm not digging at service managers. They're great, and they can be very helpful. But ultimately, they have a boss. And ultimately, even though these dealerships are independently owned and operated, they're not going to march into court and be like, oh, yeah, absolutely, this car's a mess. They not necessarily going to lie. And that's not to say that they won't come in and tell the truth, but usually it's months later that they're coming into court, and they can say, I just don't remember. I don't recall. I don't recall that happening. I don't think that I replicated an issue. There's ways to kind of move around it that can make it tricky and make it difficult for us to be able to sort of pinpoint that they said they duplicated the issue and that they confirmed it in a courtroom.
Yeah, absolutely. I can't tell you how many times I've had the exact same thing where a client has said, call this person or call that person. And I recently had a case, and I'm sure, Emma, you'll remember as well, where the client said they got pulled over and the police officer duplicated it. Said, if you could find that police officer, I know he'll remember. We were actually able to track down his name, track down a phone number. We spoke to him. He didn't remember. Because it's just not as important to other people as it is to our clients, of course, with it being their own vehicle. And a lot of times these other people simply are not remembering the issue. And Emma, like you said, even if they are, sometimes they're a little bit hesitant to admit that. So if we can get it on a repair invoice, that's always best. And the other thing that I always tell clients, continuing on about how important those repair invoices are, is don't stop getting them just because we've instituted a legal claim. You want to continue to get them. The more we have, the better. The more recent ones we have, the better. A lot of times clients will say to me, yeah, I'm still having the issue, but I stopped bringing it back when I started this claim, or I've just given up on it. It seems so futile. It seems like such a waste of time to continue to go back when they're not repairing it, which I completely understand. It's a total pain in the butt to go to get a loaner, to take car seats out of your car. I completely understand all of that, but it is just of the utmost importance to continue to get those repair invoices. The more, the better, and the more recent ones we have, the better off you will be.
Right. It's just, like you said, it's not always at the top of their mind. It's not something they're going to remember. I was the one who actually spoke to that police officer that you referenced, because it took forever, multiple phone calls to get in touch, just simply because of all the different hours that he was working. And yeah, he basically said that he didn't remember that. He didn't remember anything going on with the gas pedal. And it's not that he was lying to me, and he doesn't even work for a manufacturer. He doesn't care. He's got no skin in this game. But like you said, he probably pulled over hundreds of people in between then and now, and they just don't remember those things. So you can't hang your hat on that. You have to make sure that it's written and that it's documented. And some clients too say, well, I recorded it. They didn't know, but I had my camera going. I have a recording of it. And that's also tricky too, because each state's a little different when it comes to that, right? Some states you have to have both parties consent in order to be able to record them and provide that into evidence. Some states are a one-party consent law, meaning one person just has to consent to recording, but some are two. So we can't always get that information in or get that evidence in just because you sneak a recording of it, unfortunately. It doesn't work that way. And sometimes the recordings that we get sent, the client says, oh, this is what they're talking about. But when you're looking at it sort of like in a bubble, right? We're just watching this clip that they have. We don't have the context, and it doesn't always give us much. So it's not always the best route to take. Usually you're better putting your efforts into getting it documented on the repair record.
Yeah, that's absolutely true. And I actually once had an arbitrator a couple of years ago who the recording actually really rubbed him the wrong way. He was like, wait a minute, you recorded this person? Did they know you were recording them? Did you have their permission to record them? And he was actually really turned off. and really didn't even want to hear what they had to say. So absolutely, the repair invoices are your strongest piece of evidence.
Right. And so once we have that, right? So let's say we get on a case, we've got multiple visits to the dealership, we have a confirmed defect. What are the next steps that generally are taken? And I know that it varies state by state in terms of how this notification is given, but I'll let you talk about what steps we take next when starting the claim.
Yeah, so we then submit a claim directly with the manufacturer. We always like to start with those pre-litigation claims rather than jumping right to filing a lawsuit. A lawsuit takes time. It's usually if you're going to file a lawsuit, you're signing up right away for a year of litigation unless the case can be settled early on. But typically they take a lot of time. So a lot of manufacturers have what's called a pre-litigation program, meaning rather than jumping right to filing a lawsuit, we can file a claim directly with the manufacturer. It's usually as simple as sending them notice of our representation and saying, we believe this vehicle meets the guidelines of the Lemon Law and the breach of warranty law, and we're asking for remedy. We're asking for a buyback of the vehicle or in the alternative, a cash and keep. Generally speaking, we hear back within about 60 to 90 days, and it's usually as simple as that. We send them the documentation, we send them our representation letter, a little bit of time passes, and they'll get back to us. There are some states that there's a few more hoops to jump through, especially if we are going after a buyback, but generally it is as simple as us sending over a notice of our representation and letting them know that we are claiming that this vehicle falls under the Lemon Law.
Right. And to sort of expand on what you said in terms of the states having different requirements. So with some states, not all of them, like Pennsylvania, you don't have to send, written notice via certified mail return receipt requested. PA lets you pick. You can send them a letter. You can go right to court. You can kind of handle it in whatever means you or your attorney thinks is best to push the case forward, whether that be informal dispute resolution or otherwise. But then there's other states like Georgia and Ohio where you have to send notice to the manufacturer via certified mail return receipt requested, notifying them that, hey, you have a potential Lemon Law claim, your VIN number, the defect you have, all of that information needs to be included in there and sent off to the manufacturer before you are permitted to take those next steps of going in front of the Attorney General's office, filing the lawsuit, whatever path it is that the state requires you to take. You often have to send that notice first. And most states' attorney general's websites have all the details and information you need to put into that letter. But that's also something that our law firm or whichever attorney you choose to go to should be able to handle for you. They should know everything that goes into that letter and have it all prepped and ready to go to send it off to protect your claim so that that notice requirement is met before taking those next steps. And for those states, what I tell clients is, I understand that you're ready to really push it forward, and this notice sort of gives them what says a final repair attempt within it, right? So in many states, the final notice requirement actually serves a number of purposes. So the first one being just general notification. Hey, we've got a potential Lemon Law claim over here. Do what you need to do to try to rectify this, along with giving them a final repair attempt. So a lot of states say in their letter, like Ohio, for example, you have 7 days from receipt of this letter to repair the defect within my vehicle. Or in Maryland, you have 30 days from receipt of this letter to repair my defect. And that's something, unfortunately, that we have to send. And clients sometimes can get frustrated with that because they're like, listen, I've already been back 3 or 4 times. Why are we giving them another attempt? And unfortunately, on that, our hands are tied. We have to do it. The law says that we have to. But it doesn't necessarily mean that the manufacturer is going to take advantage of that final repair attempt. And it also doesn't mean that they're not going to buy it back just because they were given this final repair attempt. We've had it before where manufacturers reach out to us and say, hey, we got your final repair attempt letter. We are ready and willing and ready to go. We've got a tech on standby. Get that vehicle to the dealership. And they usually name the dealership they want you to go to right away, and we'll take care of it. And then what happens, Courtney? We send our client there, and the dealership is like, what are you talking about? Nobody's here. We've heard nothing. We don't know what you mean. So, and we've learned that, right? We've learned which manufacturers do that. We kind of know the ropes in terms of who's going to do that to you. You still need to go, right? Let's get it documented. Let's show that we complied. And so usually we advise that you just set up a normal service appointment like you normally would, so you can at least get that ticket showing you were there, you were ready, but nobody else was. So it's important in that sense that we've got to go through these hoops and get this sort of stuff done so that if we do have to go to court, we have all of our ducks in a row. And then it also sort of lets the manufacturer know, hey, you've got an attorney, let's talk. And that's sort of the main kicker for us. The main purpose of these letters is, yes, it gets that part of the law done, but then it also gets them in touch with us. So maybe we can get some movement, some traction without actually having to go to litigation.
Yeah, absolutely. I think you're exactly right. I always tell clients the same thing. It really serves two main purposes. One, it's letting them know you're being represented and they're going to take this seriously. And two, it just satisfies that requirement under the law. I honestly don't know if I can think of a time in recent memory when we filed a claim, given them that final notice of repair, they've gone out and actually, all of a sudden repaired it. It's just not something that happens. It really is just a legal formality. You have to show up. You have to go do it. And then we're just able to check that off and move along.
And if the off chance that they can repair it, as I say to the clients, listen, that's not a bad scenario because we can still get you cash. We can usually still get you money from them because you've had to go back so many times. Of course, it depends on how many visits you've had and the severity of the case and things of that nature. But generally speaking, as I tell them, now you don't have to worry about getting a new vehicle. We could get this one fixed, get you money from the manufacturer and send you on your way, as opposed to, getting a buyback, which sometimes is great, sometimes it's not, because you do then have to enter into new financing, find yourself a new car and things of that nature, which some of our clients just, don't really want to do. So there's ways that we can maneuver this and work with it to make that sort of final notice and that notification to the manufacturer work to our benefit, to try to get something done quickly, as opposed to, like Courtney said, jumping into litigation, which, depending on the manufacturer, Courtney, sometimes we can get these cases settled sooner rather than later, but you just never know. And so there's no guarantees that we'll get it done quickly. We do our best to gauge that and explain to you, okay, we've dealt with them before. We usually can get it done around this time, or we've dealt with them before and you're going to be in this for the long haul. So all of those factors come into play when doing this. And similarly, kind of running off of that, when we're in negotiations with them. So we sent them the letter, right? We gave them notice. They did or didn't do the final repair attempt, or the final repair attempt wasn't required, like under breach of warranty, right? For some states, all you have to do is send a letter just notifying them that you have a potential case, but there's no final repair attempt necessary when you're just pursuing a breach of warranty claim. So, but then when we're taking that next step of negotiating or talking about a settlement, Courtney, I'm going to let you sort of talk about what strategies you use when negotiating with these manufacturers and what sort of points you take into consideration when determining, is this a good settlement? Is it a bad settlement? Should we pursue litigation, or how should we go about navigating these next steps?
Yeah, I think one of the biggest things we look at is, what is the issue? Like we were talking about before, the first thing we look at is, how old is the vehicle? How many miles does it have on it? And that kind of gets us in the door. But then once we have that offer and we're trying to determine how much money can we expect to see here, is this a good offer or is it not? We're looking at the type of issue it is. I always say it's kind of a sliding scale. Can range from 5% of the purchase price up to 20% of the purchase price, all depending upon the severity and the repetitiveness of the problem. Is it an engine or transmission issue that occurred 7 times? Well, you're going to be looking at the high side. Was it a radio issue that occurred 2 to 3 times? In which case, you're going to be looking at the lower side. A lot of times clients will say to me, well, I already have 3 invoices, or I already have 6 invoices. Isn't that enough? Because I'm always saying the more the better. It's a gray area. There is really no black or white. Yes, this is enough. No, this is not enough. The more the better. And the more money we're generally going to be able to get you, the more invoices you have. So yeah, maybe you have 6 invoices but you haven't been back in 6 months, yeah, I'm pretty confident I'm going to be able to get you money. But if you're able to go back again, even though we know you're probably not going to be able to repair it and it does seem futile and it does seem like a waste of time, it likely is going to equate to more money for you. So that's really how we gauge it. There's some other things that I'll look at in sense of, are you still within the lemon law period? Was this kind of a nominal settlement offer for not so big of an issue? But you still have a year left in the lemon law period, in which case maybe you don't want to take this settlement because a bigger issue could arise next month and it could then happen multiple times. And that would have entitled you to a far greater settlement. And here you are now having accepted the small settlement very early on. Whereas on the flip side, if you're already past the lemon law period, you've had your vehicle for a few years, we know that that's not going to happen. You're not still within the lemon law period. So if we're able to get you this cash settlement, it's most likely going to behoove you to take it because there is no chance that some other issue is going to crop up still within the lemon law period.
Exactly. And that's why I think it is so important to have an attorney on your side when doing these negotiations. I mean, just this morning, our intake team reached out to us saying, hey, can we help this client? They got 2 months of payments back, but the issue's still going, but they had them sign this release. And we reviewed the release and we can't. They basically gave away their rights for 2 months worth of payments, which is not something that we would have advised. But it's very tricky. And that's why it's important to have an attorney, because not only can we help with the legalese that's written within the contracts and what it actually means for you down the road, but we also have a direct line of communication with these manufacturers. So one of the biggest complaints that I hear from clients when they're trying to deal with customer care themselves is that they don't get back to me. They don't reply to me. They don't respond. And that's not to say that that doesn't happen to us sometimes, that these manufacturers, and that's not to say that that doesn't happen to us sometimes, that sometimes the claims manager or the attorney that's working for them is non-responsive. There are things that we can do, though, because we know other people there. I've done it before where I've reached out to somebody else and said, hey, this person has not gotten back to me in 3 weeks. I need you to go over their heads or something of that nature to try to push it along, because we work with a lot of the same people. So it helps give us a leg up when we're negotiating with these manufacturers to push them a little more than when you're calling into customer care, getting a different representative every time, giving them your case number every time, having to go through everything again with them. Whereas we already have a case going, we have a rapport with these claims managers or attorneys, whomever they have handling it, depending on manufacturer, to help get your foot in the door and get your best foot forward. There's different strategies that we use as well, just in the sense of knowing the law, right? So you can have them. I've had it where manufacturers have told clients, oh, well, you've got an aftermarket part on your vehicle, so I'm sorry, we can't help you at all. Your warranty is void. That's not true. That is not true. It all depends. Is that aftermarket part causing the issue, or is that aftermarket part completely unrelated? You can put whatever you want on your vehicle. As long as it's not what's causing the defect, you still have rights. And they know that we know that. They know that they can't use the same sort of, evasive language that they would use with a client, right? Or with a consumer that's just calling in. And who knows, that customer care rep, that could be their first day. And they're just, throwing things out there that they think they know, but they are mistaken. So there's lots of different ways in which having an attorney is really beneficial, along with just generally having that threat of litigation behind you. You have an attorney. We have the power to file the lawsuit. So that pushes it along, because otherwise you're just a consumer calling in with some complaints. They'll try to make you happy with maybe like a payment or two and send you on your way. There's a little bit more heaviness to it than just doing it on your own.
Yeah, it's absolutely true. And I've had potential new clients call us so many times and say they've offered me X number of payments back, the amount of time that the vehicle spent out of service. That's what they're offering me back. And a lot of times people think, oh, all right, that's a good offer. They're offering to pay for the vehicle while it was out of service. And they have no idea that you're actually entitled to so much more than that we can actually get back a percentage of your purchase price, which usually comes out to way more than just those couple months of payments. So that's why it really is important, Emma, like you said, to speak with an attorney, know your rights, know what you're entitled to, because a lot of times you are entitled to a whole lot more than what those customer care representatives are offering you.
Yeah. And if you're not, we'll tell you. I've had it before where I've been like, this is a decent offer. I think you should take it. I don't think I can do better, because we're able to use our experience and what we've seen in other cases to make that assessment, because all of this is a case by case basis. There's no one blanket answer for everybody. So usually we take it and we look at it and say, okay, who's the manufacturer? What's our experience with them? What's the defect that you have? Is this a viable offer? And sometimes if the case falls short and they want to give them a couple months of payments, that's okay. But I wouldn't accept that if they're making you sign a release for them. And some manufacturers do, some manufacturers don't. Some manufacturers will just give you the cash, and then you're still free to bring a future lemon law claim if the issue still is ongoing. And what'll happen is that money will just, if you get a repurchase, will just be, deducted from that, since you already got a portion of your payments back. But otherwise, if they want you to sign a release for 2 months of payments, that's something that we can help you evaluate and say, okay, is this a good idea or is it not a good idea? How is this going to hurt you in the future, or is it not going to hurt you? These are all things that we can help evaluate on this case by case basis to know what works best for you. And similarly, so kind of coming off of that, based on the offer that we have. So let's say, for example, we have a case where we have an offer that, let's just use hypothetical numbers here. All right. So you talked to the client and you said, okay, I think that this case is worth, 15% of your purchase price back. I would say ballpark like 6,000 to 8,000, right? Manufacturer comes back and they're 3,000, no more. That's all they're doing. How do you evaluate that? How do you determine whether to accept it or whether to go to court? What sort of strategies are you using? What experience are you leaning on when determining whether you think it's worth accepting that and resolving it, or you think going to court is the best idea?
Yeah, that's something that a lot of factors go into, and it really is a case-by-case basis. So what was the issue? What was the purchase price? Do the quick math, the percentage of the purchase price. All right, this is 5% of the purchase price back for a serious engine issue. And we know about what we would be able to see if we go to court, just by knowing the purchase price, what the issue was, and how many times the vehicle was back. We can estimate, all right, if we go to court, at the culmination of everything, after we litigate for a year and a half, 2 years, however long it might be, and we actually get to court, we're probably looking at X number of dollars. And a lot of times I'll leave it up to the clients. I'll say, look, this is the offer. If we go to court, it's possible that we would see this much more. However, it's going to be a year and a half down the line. Is this amount of money worth more to you now because you can have it now and you just want to trade out of the vehicle? So that's something big that comes up. Are you just looking for a quick payout and you're going to go trade out of this vehicle? In which case you might be willing just to take the smaller offer because you're going to get out of it anyway. Whereas if we file a lawsuit, we're going to need you to hang on to that vehicle at least for a bit longer. So that's one thing. Are you willing to hold on to the vehicle? Is the issue fixed or is it still occurring? If it's still occurring, that would sway me more toward let's file a lawsuit, because that case is just going to snowball and continue to get stronger and stronger. So when we get to court, it's going to be an even stronger case than it is right now. Whereas if the issue is fixed, maybe they're offering you a few $1,000s now. By the time we get to court, that issue will have been fixed rather than for a few weeks or for a few months, for maybe a year and a half. And it's actually going to become less likely that we'll recover at that point because the issue has been fixed for so long. In that case, it might be more worth your while to take the offer that's on the table. So those are the things that really go into it. Do we think the case is going to get stronger because you're going to continue to have the issue? Or is it going to get weaker because the issue is fixed and it will have been so long that it's been fixed? And two, are you willing to keep the vehicle during this period of time?
And a lot of it hinges too on who is your manufacturer, right? We know the manufacturers that sometimes we just need to file. We need to file to get their attention. We need to file to push them along. And then there's other manufacturers that we know that filing, we're just going to end up trucking along and going to litigation in terms of going to arbitration, going to trial, and having to do all those things with them. So a lot of it really leans on our experience, because at this point, as we've said before, we've got a decade plus between us. And so at this point, we've dealt with everybody. We kind of know how they handle these claims and what we need to do to push it forward. And usually what I tell clients when we're debating what to do with this settlement is, like you said, if we go to court, I think we could possibly get X. Is it worth this amount of time holding onto the car for this much more money? Or are you better off just taking this? And when we're in a closer gap. So let's say we recommended 6 to 8 and they're coming in at 4,500 or 5,000, somewhere not quite there, but not super far behind. I usually tell clients, listen, if they're within the ballpark, if they're near where we want it to be, it's not always worthwhile to push it to litigation for $500 to $1,000 more, when if you calculate your time going into this, you're just getting money back for your time. It's not really beneficial. It's usually when we're super far apart. And, Courtney and I agreed, this is a strong case. This is what they're saying makes no sense to us. We highly advise pushing this forward because we are very confident that we can do better. Those are all things that come into play. So, and all of this is why it's so beneficial to have an attorney when you're going through these claims, because a lot of people say to me, this is my first lemon law claim. I don't know what to do. I don't know what the normal process is. I don't know how much money is normal. I don't know what I'm entitled to. Can you help me out here? And that's where it is beneficial to have an attorney, because those are things that we know, and that's what we can guide you on. And if and when we do come to a settlement, Courtney, I'll have you kind of go through what the settlement process typically does involve and how do we ensure that the process is completed and that it goes smoothly as best we possibly can.
Yeah, so once we finally do reach that settlement, the manufacturer is going to want you to sign a settlement release, which basically says for you, and give your name and this vehicle and this VIN number, you're releasing all future legal claims against them. And what that means is you get one bite at the lemon law breach of warranty apple. You can't go back and sue them again or bring another formal legal claim for the same vehicle. And so that's something that you would have to sign off on. It will show how much money you're getting. It will show how much money is going to your attorney, because like we've discussed in past episodes, lemon law, breach of warranty, it is free of charge to you. The manufacturer has to pay all of your legal fees. So that will all be disclosed. And you'll sign off on that release. We send it back to them, and then we generally have a check within 30 to 45 days. There might be a couple manufacturers that are more on that 60-day mark. And we'll ensure that you're getting your check on time and in the amount of time promised. For a buyback, it can typically take a little bit longer. Sometimes it does take upwards of 90 days because the process is a little bit more complicated. Not only are you signing off on the numbers, but there's a whole lot of documents that need to be gathered. You need to call your bank. You need to get a payment history showing everything that you've paid so it can all be reimbursed to you. You have to get a payoff quote showing what's left on your loan so that the manufacturer can pay off the remainder of your loan. So you'd have to gather those documents. So everything does take a bit longer, but we would be here to help guide you, explain to you exactly what it is you need to get, because sometimes that can be rather confusing. That'll all get given back to the manufacturer. And then what's called a surrender date would be scheduled, where you will go to the dealership, give them the keys to your vehicle, if the vehicle's not already there, sign off that the vehicle will no longer be in your name. They will take your registration. They will take your license plates. So none of that is any longer in your name, and you'll be given your check. So that process would take a little bit longer, typically, like I said, in the 60 to 90 day range. But generally, once we reach a settlement, it is rather simple. And for the most part, we're able to get you that money pretty quickly.
Yeah. I mean, as we always say, every case is different. There's always the one-off. There's always, that one case. You and I both have repurchase cases going on right now that are really tricky. You had a vehicle that said it was going to be picked up from the dealer, and the dealer's like, it's not on our lot. We don't know where it is. And then lo and behold, how many months later, they were like, oh no, we do have it. Sorry about that. And can be an arduous process. I similarly have a repurchase where the dealership agreed to come on board and to facilitate the repurchase. The client went, signed all the paperwork. One page was missing, a notarization. And I was like, oh, simple. We'll just get it notarized and mail the surrender documents in, no problem. Well, lo and behold, the dealership didn't understand that it was a vehicle surrender. They thought it was a lease turn-in, which means that they then get to sell that car. They can't do that now. They've decided to back out of the repurchase as the facilitator, and now we're starting all over again. So there's definitely times in which monkey wrenches are thrown in, but they're few and far between because we generally know how it goes. We can get these cases moving along, but that's also why it helps to have an attorney because, again, instead of calling customer care and trying to push your claim through and the importance of it, we have contacts, we have people we can reach out to push it through, along with, like in your case, Courtney, with that car, we had to threaten to file to enforce the settlement agreement. We said, we are going to file this motion if you don't get back to us.
Yeah, I was actually just going to say the exact same thing. So what happened in that case was the vehicle was out of state on another lot because our client had been traveling when the issue occurred. She now was back several states and several hours away. And the manufacturer very kindly said, all right, you know what? We're going to buy this vehicle back. You don't have to go down there and pick it up. We're going to have it transported up here and have the surrender take place up here. But when they called the dealership to facilitate that surrender, or that transfer rather, they said that the vehicle wasn't there. And it was mind boggling. Like, what do you mean you lost this vehicle? It's a car. It's not a set of keys. It is a car. You either see it or you don't. Our client actually thought she might have to report the vehicle stolen. It was a whole thing. Lo and behold, months later, it turns out the vehicle had been there the whole time. But yes, in order to get them to actually find that vehicle, we had to threaten a motion to enforce the settlement, a motion for summary judgment, because just continuing to follow up with them really wasn't getting us anywhere. We heard crickets for several weeks. And it wasn't until we really dug our nails in that they finally spoke up, finally got in touch with the right person and found, for lack of a better word, this vehicle that had never been lost in the first place. And exactly, I can't imagine if our client had been dealing with them on her own, how much longer that would have continued to go on.
Yeah, it can be hairy. Things can get complicated very quickly and unexpectedly. And again, that's why it helps to have an attorney that can help guide you through. Most cases, though, are boilerplate. Most of them, you go, you surrender it. And each manufacturer does do the repurchase process a little differently in the sense of whether you get your check at surrender, whether it's sent to us at our offices. But we do our best to push it through as quickly as we can and get that money back out to you when the check is sent to our offices to process instead, because we know now you don't have a car and you're hunting for another one. And then there's other settlements that we have too that are strictly just a cash basis. We call them a cash and keep. And those are our breach of warranty claims where you don't have to surrender the vehicle. You're keeping your vehicle, but you're getting a cash payment from the manufacturer. You do also sign a release, and the release, just like Courtney says, hey, I'm not going to bring another Lemon Law or breach of warranty claim against you for this vehicle, but my warranties are still good and my title is still clean. So if you accept the cash settlement, your vehicle's not branded a lemon, which is a question we often get because clients are like, well, what is this money going to help me if I have a lemon title now? No one's going to want this car. So we explain that it doesn't have that effect on your vehicle. It's actually a confidential settlement between you and the manufacturer. And on those, it's much easier, right? The check comes, it is placed into an IOLTA account, and then the check is dispersed according to the settlement agreement and the authorization. And the reason why they send the checks to our offices generally is because attorney's fees and costs are included in these settlements. So what's different about Lemon Law and breach of warranty is that there's an actual caveat within the law that says if we're successful, the manufacturer pays our attorney's fees and costs. In the case of a repurchase, they pay our fees and costs on top of your repurchase money. In the case of a cash settlement, it's inclusive. So meaning, let's say we call our client and say, hey, we've got $6,000 for you from the vehicle's manufacturer. That means our client is receiving $6,000 and they're paying our fees on top of that. And so that's how those settlements are able to pay the attorney's fees and costs, and our clients are able to evaluate exactly how much money they're getting back, as opposed to us taking a percentage, right? Of saying we have a $6,000 settlement, and then lo and behold, you get a check for only, $5,000 or something because it wasn't clear what the fees were. Because the fees are paid in addition to, we're able to explain that and make it clear to the client exactly how much they're going to net so they know the type of agreement that they're entering into.
Yeah, absolutely. And that's a question we get all the time. I'll take a settlement to a client and they'll say, all right, well, how much of this is actually going to be in my pocket? And I always explain 100%. Fees under Magnus and Moss breach of warranty statute and under the Lemon Law are paid by the manufacturer. They're what's called fee shifting statutes. And basically the legislator understood when they were drafting these laws that if a consumer was going to have to pay an attorney on top of anything that they were getting, it really wasn't going to be worth it for them to file these claims, because a lot of times with these breach of warranty claims, clients are getting back a few $1,000s, sometimes several $1,000s, sometimes a couple $1,000s. So if they were paying an attorney, it wasn't going to be worth it for them. So what happens is if you recover, the manufacturer has to pay all of your legal fees. If you don't recover, we just don't get paid. So under no circumstance does it come out of a client's pocket. So yeah, they're constantly, or we often get the question, what percentage of this is going to go to me? What percentage of this goes to you? And the answer is always 100% goes to you. The manufacturer has to pay our fee on top of what goes to you and add it to your settlement. You use the word inclusive. Exactly. And they send one inclusive check, which is why it comes to us, because it's made out to our client and to us for their settlement and our fee. We deposit that check. As soon as it clears, we send our client's portion out to them.
Something that's really important for consumers to evaluate when deciding what attorney to sign with and who to go with is the representation agreement. And our representation agreement specifically lists what our attorney's fees and costs are at different stages of the case. So we explicitly lay out that these are what our fees are depending on where we're at. And I just mean that in terms of, did it settle in pre-litigation? Did we have to go to court? Did we have to bring in experts? We have all of that listed, so it's very clear what our fees are. And underneath those fees in bold, it specifically says in our agreement that under no circumstances are you responsible for paying these fees. And that's something that's really important when you're looking at these representation agreements, when you're evaluating which attorney to go with. How clear is it what their fees are? How clear is it that you will not be responsible? Or is there maybe some language in there that makes it confusing? Is there some language in there that says you might be responsible for our attorney's fees and costs, but they don't really say under what circumstances? Those are all important things to take into account. How well am I able to understand this agreement that I'm reading? And how well does it delineate what the exact attorney's fees and costs are in my Lemon Law case? That's something that's really important, I think, for consumers when they're evaluating who to sign with is, do I understand what I am signing? What am I going to be responsible for? And what fees am I going to potentially have to pay, if any at all? So I think that's sort of the best tip that I can give when you're looking at different firms, looking at different representation agreements. Which one do you feel most comfortable signing? Which one do you feel you truly understand?
Yeah, that's absolutely true. I've seen other attorneys' representation agreements say that we would take a fee that we believe is reasonable in our discretion. Well, that raises some red flags right there. That's really not something you want to hear. Like you said, our representation agreement is very clear cut. It gives the exact amount of fees that would be paid in each stage of litigation. It's short, it's simple, it's to the point. And I'm sure you'll remember we actually had a client recently call us that had been with another firm, cut off ties with that firm, and called us. We filed a claim and the manufacturer told us that there was a lien on the vehicle put there by the other firm. And we immediately were like, what are you talking about? I've never, in 14 years of doing this, I've never heard of such a thing. So we called our client and asked her to get the representation agreement that she had signed with that previous firm and send it to us. She sent it to us. It turned out to be 8 or 9 pages, incredibly long. I actually couldn't believe how long it was. And when I got to the 8th or 9th page, after quite a while, I saw that there was actually a caveat in there that said, if we get an offer that we believe is good, but you don't want to take it and you cut ties with our firm, we can put a lien on your vehicle to get our fee. And I couldn't believe it. I couldn't believe that that was legal. I couldn't believe that that was ethical or something that someone would actually do. Our representation agreement says nothing to that effect. If you don't recover, we don't get paid, period, for whatever reason, whether it's because we weren't able to get you an offer or because we got you a fantastic offer that you just decided not to take. Under any circumstance, you can walk away and you would not be charged.
Yeah, I agree with you completely. And I think that's a great sort of point for us to end on today. Thank you all for listening. We hope this was helpful. For more information, please visit lemonlawcar.com or you can call our intake line at 1-833-4-CAR-LAW. Thanks and have a great day.
Thank you all. Bye-bye.
Lemon Law Unpeeled is for informative purposes only. It is not to take the place of legal advice and does not create an attorney-client relationship between the viewers and Robison Lemon Law Group. Individual results also may vary as outcomes are determined on a case-by-case basis.